The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Four cases are submitted this morning. Those cases are in re the detention of Stephen Curtiss, in re the detention of Calvin Matlock, Aaron Dindinger versus and others versus Allstate Inc. and Scott Mills. And the final case is Eric Dempsey versus State of Iowa. The last case is submitted without argument, and we'll now hear the arguments in the Curtiss matter. Mr. Addington.
Thank you. May it please the court, counsel. I represent Stephen Curtiss in this matter. On July 30th, 2008, Stephen Curtiss was found to have a mental abnormality and was committed to the Civil Commitment Unit, commonly known as Counsel, until such time as he no longer suffered from that mental abnormality. Under Iowa law, someone committed to the Counsel facility is entitled to an annual review each year. And in September of 2010, Mr. Curtiss had that final hearing to determine whether he had a mental abnormality or not, and Judge Pattinson ruled that the state had not met its burden and he should be discharged. However, he ordered Mr. Curtiss to be discharged with supervision, or to be released with supervision, to the House of New Life in Omaha, Nebraska. Instead of appealing that ruling, the state filed a motion to amend and enlarge. And they argued that the House of New Life was not an appropriate agency under the release with supervision plan or statute. So by that time, Judge Pattinson had retired. Judge Rue was hearing the case, and he ruled that Mr. Curtiss's release with supervision should be held at the Counsel facility in their transitional release program. That was in January of 2012. By that time, over a year had passed, a year and 3 months, I think it passed, since Judge Pattinson ruled he had no mental abnormality, and yet he was still held in Counsel. He had not set foot out. They instituted a plan where he was supposed to do a lot more treatment, even though he didn't have a mental abnormality. And 8 months after that, they revoked his release with supervision plan, and he is now back in the secure part of Counsel.
Question I have, Mr. Addington. Now, Mr. Curtiss did not appeal. It seems to me, reading the briefing, a lot of the objections are related to Judge Rue's February or January 2012 order, which wasn't appealed. Am I correct?
Correct.
Could that order have been appealed?
The order could have been appealed on the basis that transitional release was not the proper place for him. I suppose it was still. I think the argument would still be made. It's no big deal. We'll let him out in a couple of months. I mean, so I don't think it was really ripe for appeal. It could possibly have been appealed at that time. I think the key part is when they revoked him 8 months later. He had only been out 6 times in that time, supervised each time, and they revoked him for not following the release plan as they outlined, which was more treatment, which Judge Pattinson ruled he didn't have. So what we have now, we have a man that is in the secure facility at Counsel with a ruling that he doesn't have a mental abnormality, which I think is in conflict. 229.9A is the transitional release, and that is in conflict with the statute, because You can't commit a person without a dual finding of mental abnormality and dangerousness. How do we keep one now in there without that finding? And furthermore, he has to go to be released now. He would have to prove again that he doesn't have a mental abnormality, that he's no longer a danger. The trouble with that is we have a court order saying he wasn't, that he wasn't a danger and he didn't have a mental abnormality. So I think the statute is in conflict with the rest of the statute.
Well, what do you make of the language of 229A.9A that talks about with or without supervision? How does that fit in here?
I don't think it fits, is my contention. I think that the key is whether you have a mental abnormality or not in order to be in CUSO. Once you are determined that you don't have a mental abnormality, the idea that it's with or without supervision in the best interest of the community, it seems to be violative of the statute. Under Hendricks, under Selby, you have to have the dangerousness coupled with the mental abnormality. But under 229A.9A, you just have to have the best interest of the community. And I think for that reason, what we end up with is exactly what we've ended up with Mr. Curtiss. A person has judicially determined not to have a mental abnormality, locked away at CUSO. Because of that, I think 229A.9 doesn't comport with the rest of the statute.
Well, is Mr. Curtiss confined today because he's being punished for violating his supervision terms, or is he confined because he needs treatment?
He's being confined today because the state brought an action to revoke his release with supervision. And they brought that action because he was not complying with their memo in December of increased treatment. The trouble with that is twofold. One is that there was no time limit on when that treatment should be done. He wasn't progressing as fast enough for them. And second of all, the CUSO decided that he needed more treatment, even though Judge Pattinson had ruled that he no longer had a mental abnormality and was no longer dangerous. So he's being confined because he didn't meet their expectations. But their expectations ignored Judge Pattinson's ruling to begin with. So it's not a punishment, but he's being confined, and Judge Oath, who recommitted him, never found that he had a mental abnormality. And that's the other problem with this statute. We can revoke anybody without a finding that he has a mental abnormality or his dangerousness. If they aren't following the release plan as someone determines, they're revoked, not because they have a mental abnormality, but because they didn't meet certain release plan. And you can't, we can't commit Mr. Curtiss without that mental abnormality. We can't hold him now when he doesn't have it.
Was there an actual petition filed in this matter for discharge?
Yes.
Yeah, and when was that filed exactly? You know, we have the annual hearing, and then, of course, the code provides that, you know, at the time of the annual review, if he has actually filed a petition for discharge. So we do have a petition for discharge in the appendix?
He was found, I'm not sure you have a petition for discharge. He was found in the initial hearing to be entitled to a hearing on discharge or transitional release. We were in the initial hearing with Judge Pattinson. Mr. Curtiss' position was he did not want transitional release. He only wanted discharge.
So there's no actual petition. You know, the code makes numerous references to an actually filing of a petition for discharge. So when you get your annual report, then either you have the probable cause hearing.
Sure.
And then you go ahead and you either have the annual hearing, or else, again, the code provides that if, in the meantime, you actually filed a petition for discharge, then the annual hearing's kind of postponed and you go right to the hearing on the discharge. That's why I'm asking,
Sure, you can
was
do,
the code complied with as far as a petition for discharge?
the code was complied for because you can do two things. You can either go to your annual hearing and argue for discharge or transition release, or outside of the annual hearing, at any time, you could then apply for discharge.
And was this done at the annual hearing?
It was done at the annual hearing. His annual hearing came up, and he met the first step of to have a final hearing in the matter. And then Judge Pattinson's ruling was on the final hearing on the annual review.
But not on a petition for discharge?
No, because Mr. Curtiss didn't need a petition for discharge since he'd received a final hearing on the matter. The petition for discharge is for some time. If I decide today I want to discharge, I could file, and my annual review is not till March.
And I guess I want to go back to the order of Judge, was that Pattinson, the first one?
First one was Judge Pattinson.
Judge Pattinson. And it looked to me like, in reviewing the code, that really the only thing that he could do was to either, well, he kind of mixed up the terms as far as I'm concerned. You know, he says he needs to be discharged with or without, with supervision in this case, and that seems to be inconsistent. And it seems to me like Judge Rue's order then brought it into consistency, where you can get released, but it's going to be with supervision. Then you can file your petition for actual discharge. But it's kind of, to me, an intermediate step. Am I just wrong in looking at it that way? Because it seemed that Judge Rue's order was a clarifying order.
I agree with you that it's confusing, but I think the confusion comes from the statute, not Judge Pattinson. If you look at 229A 9, Section 9, it says that after the court or jury has determined that the person should be discharged from the program, but the court has determined it is in the best interest of the community to order release or without supervision before the committed person is discharged.
And that's exactly what Judge Rue did, though.
That's exactly what Judge Pattinson did. The trouble is that Judge Rue, first of all, ordered him back into transitional release, which is a completely separate entity in itself. It's not release with supervision.
What about the following subsection 6 that says a committed person released with or without supervision, which is what Judge Rue did, is not considered discharged from the civil commitment under this chapter?
And you're right, Judge Zager, but that's the entire problem with the statute. First of all, to be discharged under a jury or a judge, you have to find that he no longer has a mental abnormality, that he is no longer dangerous. Once that determination is made, then really the state has no jurisdiction to hold him any longer. So he should be just discharged at that time. Because now we're making the determination, you don't have a mental abnormality, but it's in the best interest of the community. So it's the problem with the statute, not necessarily Judge Pattinson. Judge Rue's problem was that he ordered him back into the Counsel facility.
Ordinarily, we read the statute as a whole and try to harmonize the provisions that appear to be in conflict. Couldn't we read it that once you're found a committed person, even if later there's a finding that you no longer have that abnormality, you can still be released with conditions under the later provision? Otherwise, as you argue, we just have to read that related provision out of the statute, or is it surplusage?
Yes. I don't believe that you have any hold on that individual once he's determined not to have a mental abnormality. The only way we commit them is by determination of mental abnormality and dangerousness. Hendricks said that the only way the statute is constitutional is to find that dual mental abnormality and dangerousness. Once that's gone, then we can't hold them any longer.
Counsel, as I was making my way through the appendix, I noticed some documents that made reference to probation. And my understanding has always been that we viewed this as a civil commitment process because it didn't involve a criminal framework. What are those documents referring to probation, and do they have any place in a case like this?
I'm not sure exactly what documents, but there is a provision going on now and has been for a while that release with supervision would be transferred to the probation in that district, and then they would supervise instead of DHS. And since I don't believe that you should have any transfers or release, no, I don't believe there's any way that should happen. But again, the trouble with it is, if you look at the December document in Mr. Curtiss's matter, where they put on all these extra conditions for treatment, and that was after a judge had already determined that he didn't have a mental abnormality. And in that document itself, the CUSO says, we don't agree that he's not dangerous. We don't agree with the judge's ruling. So we have somebody supervising him that didn't agree with it, that fought it and didn't agree with it to begin with. He was set up for failure. And once he didn't meet their conditions, he was returned back to the facility, even though no determination has been made that he had a mental abnormality. So we have a man sitting there without a mental abnormality, with a judicial determination that he isn't dangerousness in a facility that we can only commit them to when they have that.
Thank you, Mr. Addington.
Thank you.
Ms. Kraemer.
May it please the court and counsel, I'm here representing the state. I think the only ruling that the notice of appeal is timely for is the ruling revoking Mr. Curtiss's release with supervision status. And nowhere in the brief does it argue that that revocation was improper. And so I would believe that that argument was waived. One of Mr. Addington's arguments is that once there's a ruling that there was no mental abnormality, that it's a finite conclusion. I would suggest that mental status can change, that that's the whole predicate of treatment, that it can get better and can get worse. Also within the definition of mental abnormality, it includes risk. It includes the more likely than not formulation. The definition, and that's a continuum. It's not a dichotomous decision. So risk can change in time. And here, Mr. Curtiss, he was in release with supervision, and he could have taken more outings. He could have, you have to submit an outing request in order to go out into the community. Didn't submit any requests, didn't ask to go into the community. When he was finally submitting outing requests and going into the community, he was shopping and dining out instead of doing things like looking for an apartment or trying to set up treatment services. The release with supervision serves a very practical and important step. These individuals have been in confinement for a lengthy period of time. Mr. Curtiss has been in confinement most of his life. He has not worked enough that he can even secure Social Security. He doesn't have enough covered quarters. He has.
Why, Counsel, why aren't those shortcomings part of the treatment process? They're supposed to be in this facility getting treatment and arguably getting prepared for reintroduction. Why do we wait until the end of the detention and it's time for release before we start worrying about those problems?
They do work on those things in advance. Mr. Curtiss could have had a job the entire time he was in the transitional release program, and he didn't get one. There are other patients who do get a job, who do come up with a realistic budget.
So that was all a matter of his lack of commitment to go get one? Is that what you're saying?
There is additional treatment that is more appropriate once they're in the community. They're exposed to triggers. For example, he's a pedophile. There are no children at CUSO, so working on your response when you see children in the community is something that you can't really do until you're in the community. they do work on that at CUSO, but it's taken at another level once they're back in the community on release with supervision. So those things all were addressed. Mr. Curtiss, he has been through treatment processes before and has reoffended after those treatments. He was not somebody that CUSO recommended for release with supervision, and Mr. Addington is correct on that. They thought he was a high risk the whole time he was there. DHS is required by statute to come up with a release with supervision plan that tries to address that risk, and obviously the goal is for the individual to be successful, because if they're not successful, there's another victim. And so they put together a plan that they thought was most appropriate to address Mr. Curtiss's risk. There was a contested hearing on that, and the judge approved the plan, and so that order has not been appealed. The judge
What services are being offered to Mr. Curtiss now?
He's on the secure side, so he gets the typical sex offender treatment. He cannot get a job in the community until he gets to transitional release or release with supervision. But Mr. Curtiss has never fully disclosed his victims. He has very little empathy for his victims or anyone else for that matter. He has few warm relationships with others. He has difficulty with his criminal thinking styles. So those are all things that are being addressed in treatment.
Do you agree that he's being held without a finding of a mental abnormality?
I do not. I think Judge Rue's clarifying order clarified Judge Pattinson's order. There's also a more contemporaneous order that finds he has a mental abnormality after his most recent annual review. So different decision maker and mental status changes with time.
Is he currently a, quote, committed person, close quote, within the meaning of 229A9A?
He is. He is. One of the other things, the release with supervision revocation provisions allow you to revoke for any violation of the release plan, but as we're applying this, we're only revoking when there's also a risk. So the facility identifies a violation of the plan, the rule that was violated, and then they also have to say why it matters, how it relates to risk and how it relates to the individual's mental abnormality. And that testimony was provided to Judge Oath at that particular hearing. And Mr. Curtiss himself admitted that the relapse prevention plan is what keeps you from ever reoffending again. It's the offender supposed to study their own habits and own processes.
What was his risk assessment for reoffense at the time Judge Pattinson entered his order?
My understanding is that there were two. It was a division of experts. The CUSO expert thought he was a high risk, and then the defense expert argued based on actuarials that because of his age, his risk was lower.
And was there a finding on that by Judge Pattinson?
There was a finding on
Which did he, what level did Judge Pattinson find?
Judge Pattinson said that he couldn't find beyond a reasonable doubt that he was more likely than not to reoffend, but he did believe Mr. Curtiss remained at risk. And so that's part of the state's argument is the more likely than not threshold is 51%, which is pretty high. So Mr. Curtiss could still be at a risk to reoffend, and all of the court orders, all of them have found that he remains a risk to reoffend. And the release with supervision is the only hook that the state has to provide some supervision and to provide some treatment as the individual progresses back into the community. And if we don't have release with supervision, they're going from secure setting back out into the community with no supports.
Counsel,
go ahead. When we had the hearing, did we function under 229A8B or under 9B? Do you know?
Which hearing are you referring to?
Well, on the violations, you know, we have two code provisions, violations of transitional release. He really wasn't in transitional release, or was he at this time?
He was in the release with supervision transitional release program, so we argued under 9.
Under 9B?
Yes.
All right. And does it make a difference?
Not a whole lot. Transitional release is a violation of a rule or directive. Release with supervision is a violation of the release plan. So it's the document that's controlling, but pretty much the standards are the same. I would also suggest that the statutory construction argument that's advanced by the defense was not part of the ruling that is timely under the appeal, and so we would suggest that there's no error preservation on that. With respect to the relapse prevention plan, which is one of Mr. Curtiss's most significant treatment items to be established, that would be like the rules of the road, what he would need to govern himself appropriately in the community. And the actuarials, which was the basis for Judge Pattinson's order, doesn't take into account any of those individual factors. The science just is not sufficiently advanced that they can account for whether or not somebody is participating in treatment and how that affects sort of some of the very basic.
During the discharge with supervision phase under Judge Rue's order, who was doing the supervision?
CUSO.
So it wasn't the Department of Corrections or district correctional officers or anything like that. It was CUSO.
Not for this case. There are about 9 people who are on release with supervision status now, and we are moving to having community-based corrections do that supervision for efficiency's sake. The statute defines agencies with jurisdiction. DHS is one agency, Department of Corrections is an agency, community-based corrections. Those are all identified by the statute as appropriate supervising agencies. House with New Life in Nebraska did not meet the statutory definition of an agency with jurisdiction.
Why not?
Because, well, this was the argument that resulted in the motion to amend and clarify. Because if you look at the itemized agencies with jurisdiction, they're all Iowa governmental agencies. And to the extent that the Iowa government is going to be held responsible for supervising someone who's not even in the state, the argument of the state was that that's not within the statute.
I thought that, I don't have the language in front of me, but I thought it said includes. It didn't say is limited to these various governmental agencies.
That's correct. The position of the state is that it has to be a governmental agency, to the extent that the commitment is a function of Iowa law. There's also no basis for extending jurisdiction of the 229A process into another state. Typically for mental health commitments, if you're transferring jurisdiction from one state to another, you go through an interstate compact process.
Your view is this release with supervision concept means that the supervision has to be provided by an Iowa governmental entity?
Yes. Although if the court disagrees, we would be grateful for the guidance, because right now there's not a lot of law on release with supervision.
Counsel, I understood you to say that you articulated the principle that mental status can change, and so your view, as I take it, is that after Judge Pattinson made the determination that there was no present abnormality, mental abnormality, that at a subsequent time, abnormality recurred. And my question to you is, what was the new mental abnormality that wasn't found by Judge Pattinson?
Judge, I would argue that it's a continuum under the more likely than not standard. It's the same issue. It's his pedophilia and his antisocial personality disorder. But the definition of mental abnormality includes risk in the more likely than not formulation. And so we would suggest that the risk changed, that mental health diagnosis did not. It's just whether or not it's manifesting itself in an extreme form or in a more latent form. Typically, pedophilia can't be cured. It can be managed.
Yeah, and presumably Judge Pattinson knew that when he made the determination, right?
Right, and the definition of mental abnormality that Judge Pattinson had to work with included this embedded component of risk, and Judge Pattinson specifically said, he's still a risk, I just can't find that he's more not I'm gonna get confused, that he's more likely than not to reoffend. He didn't say he's cured of his pedophilia. There's no court order saying that. Mr. Curtiss, since he's been back in the confined setting, continues to sort of do nothing. His most recent annual review shows that he's made very little progress despite the treatment efforts that are being offered to him. And so we would suggest that he is where he needs to be. With that, I thank you.
Thank you, Ms. Kraemer. Rebuttal, Mr. Addington?
Thank you, Your Honor. Please, the court. There's several things wrong with Ms. Kramer's argument. One is that somehow there's a continuum of risk, and we can restrain someone's liberty on this continuum of risk. The statute is pretty clear. We can restrain someone's liberty in 229A when they have a risk over 50%. That they have no risk whatsoever is not contemplated in the statute. That they have a 20% so that we can then bring them back in is not contemplated by the statute. It has to be over 50%. The idea that he could have gone out and gotten a job is just a complete fallacy. He was moved back into transition release. They testified that it's like he's starting new and he didn't even belong there, so they were going to have him do all these treatment matters before they'd even release him to do that other kind of stuff. They have complete control. He is in a secure facility at that time, so he couldn't have gotten a job. They didn't allow it. The idea that DAS has some obligation to not release him until he's till they think the risk is okay is wrong when they have a court order saying he should be discharged because he no longer has a mental abnormality, that he's no longer above 50%. They ignored that court order because they thought he had a risk. Because of that, he is now sitting in Counsel with a Judge Pattinson's only ruling that has not been appealed, has not been overruled, saying he no longer met the criteria for commitment.
Counsel, on that point, as I understand opposing counsel's explanation, the notion of mental abnormality includes a factor of risk of the likelihood to reoffend. My recollection of the Hendricks case and some of the other jurisprudence in this area is that we have kind of two components, two requirements to make these civil commitments constitutional. One being a determination of a mental abnormality, and this other piece, which is the risk of likelihood to reoffend. I'd just like to hear your views, whether you share her understanding of this or whether you differ.
I differ in the sense that mental abnormality is strictly a legal term. And I think when we're looking at, for commitment, we first look to see if there's a mental condition, antisocial personality disorder, pedophilia. But that antisocial personality disorder, or that pedophilia, does not necessarily mean it's a mental abnormality. Only when you have the risk over 50% does it then become a mental abnormality. So the definition of mental abnormality must include the risk. If I'm below that, I might have a mental condition, but I don't have a mental abnormality.
In the big picture, doesn't your statutory interpretation just read all of the release without or release with supervision out of the statute?
Yes.
So that all becomes kind of surplusage, right?
Yes, Your Honor, it does, because it says that the judge must find it's in the best interest of the community. I don't believe that once you find that he does not have a mental abnormality, then you don't need to make any further determination. For those reasons, we would ask that the ruling be overturned. Thank you.
Thank you as well, Mr. Addington. The Curtiss case then is submitted.